In this episode, we will be discussing Georgia Landlord Tenant laws. The following is a summary of landlord tenant laws in the state of Georgia as they apply to residential rental property. Topics include disclosures, withholding rent, the right to enter, security deposits, eviction and termination, increasing rent, and more. Required disclosures. Before signing a lease, a landlord must disclose if the living space or attachments have been damaged by flooding 3 or more times within the past 5 years. When or before a tenancy begins, a landlord must disclose in writing the names and addresses of the owner of record or a person authorized to act for the owner for purposes of service of process and receiving and receipting demands and notices, and the person authorized to manage the premises. If such information changes, the landlord must advise the tenant within 30 days in writing or by posting a conspicuous notice. A landlord must give the tenant a written list of pre-existing rental damage before collecting a security deposit. The deposit must then be placed in an escrow account in a state or federally regulated depository and must inform the tenant of its location. Alternatively, a security bond may be used to secure all tenants' deposits. It's important to note, though, a landlord who owns and personally manages 10 or fewer units is exempt from this policy. If asked by a prospective tenant, a landlord must answer truthfully when questioned about whether the rental was the site of a homicide or other felony, or a suicide or a death by accidental or natural causes, or whether it was occupied by a person who was infected with a virus or any disease determined by medical evidence as being highly likely to be transmitted through the subsequent occupancy of a dwelling. Security deposit limit. There is no state statute that limits the amount of a deposit. However, there are requirements for disclosing prior damage and for storing the deposit in an escrow account as mentioned previously, unless the landlord owns 10 or fewer rental units and personally manages them. If the rental is managed by an outside party, there is no exemption under the law. Deadline for returning a security deposit. Upon the tenant vacating, the deposit must be returned within 1 month. If any deductions are to be made to cover damage, advance notice must first be given to allow the tenant a chance to dispute. Late fees. No late fee may be charged unless it is written into the lease agreement. Increasing rent. A 60-day notice to increase rent on a month-to-month term must be given. Longer-term leases are exempt from increases unless specified in the agreement. Withholding rent. If necessary, a tenant can hire a professional to have a repair made, but the landlord must be given a written notice of the problem and a reasonable amount of time to fix it first. If the landlord fails to make a timely repair, the tenant may coordinate the repair and deduct the costs from the rent. But it's important to note, it is not a landlord's duty to repair damages caused by a tenant or their guests. Terminating tenancy and eviction. An unconditional notice to quit and vacate the property immediately may be served if there was non-payment of rent more than once within 12 months or if the tenant is holding over after the end of a lease. There is no statute addressing other lease violations. However, a landlord can provide a notice of violations and give a reasonable amount of time to cure before an eviction is filed. The right to enter. There is no statute addressing a specific time frame for providing a notice to enter. However, a tenant does not have the right to unreasonably withhold access to a landlord who provides advance notice and a legitimate reason to enter. For more information, additional laws and articles can be found at AmericanLandlord.com.